Welcome. My name is William Bailey, and I'm the director of Georgetown Law's 150th anniversary celebrations. I'm so glad you could join us today for Building Bridges Between Law and Technology, the penultimate webinar in our virtual year of events. Next week, please join us on Tuesday at 1 o'clock p.m. Eastern Daylight Time for The Judiciary and the Rule of Law, featuring an all-star panel of judges and media experts to help us close out the 150th anniversary year. Today, I'm so happy that we have for our moderator, truly an expert in the law and tech space, Paul Ohm. Paul is Associate Dean for Academic Affairs, also Professor of Law, and our Chief Data Officer. And I should also add that he is personally responsible for many of the classes and programs you'll hear about today. We're so grateful that Paul could moderate today. Paul, welcome.
Thank you, William. Good morning, everyone. It's such a pleasure to be with you today. I remember last year when we first, really 2 years ago, started talking about our 150th anniversary. And of course, it felt very different at the time. But here we are, we've done this amazing series of webinars, and I'm just privileged that we get to take a little time out and talk about technology, law, and policy and its place today at Georgetown University Law Center. This event really, for me, reached a high point recently when we had a panel that looked at our past 50 years of this institution's history. We did it through the eyes of 6 faculty colleagues who've each been here for decades. In fact, Jim Oldham had been here the entire 50 years that he was discussing. And I was really struck by the words of our path-breaking colleague, Professor Emerita Pat King, the first woman law professor of African-American to receive tenure at Georgetown Law. Pat's work, she really was ahead of her time, was long focused on the intersection of biomedical research and ethics. She's looked at questions ranging from stem cells to euthanasia to genome editing. And at the time in the 50-year retrospective, Pat said, and I'm quoting here, "Georgetown Law has continued to develop and lead in various areas of law in their infancy. We have a capacity to evolve and not evolve slowly, to evolve quickly in areas that we can introduce to our students." Today, we're going to take a deep dive into that notion, the idea that Georgetown Law, for lots of kind of accidents of wonderful history, isn't a lumbering battleship despite our size. It's not hard to turn this institution on a dime. It's not hard for this institution to take a look at society, to hold a mirror up to what's happening in our world, and to ask where are the important, insistent questions that we as academics and students and alumni should be looking at. And so to have this conversation, I've invited 3 faculty colleagues and 1 recent alum. Our final scheduled panelist, Howard Shalansky, was unfortunately unable to join us, and he sends his regrets and his regards. There's something funny about today's panel, even if you had included Professor Shalansky. It's probably unique in this year's series. 10 years ago, none of the speakers you will hear from today had yet joined Georgetown. This is a panel and a story about Georgetown at its present, and I think what Georgetown will look to in the next few years and even beyond. And so because we're relative newcomers, I'm going to have to apologize in advance that we're probably not going to do justice to part of the Georgetown Law story. We are only here, everyone you're going to hear from, thanks to the groundbreaking work of colleagues who are still at the center of our faculty activity and life. I'm thinking of people like Julie Cohen, Jay Thomas, Tanina Rothstein, David Vladeck. You're going to hear a lot of shout outs to people like that. We're also going to be stand-ins for hundreds of alumni who learned about technology law at this school, who are pioneers in technology law and policy, who lead some of the most important corporations, law firms, civil society organizations, and government agencies. I wish we could have done a week-long event joined by a cast of thousands, but we intended to be a bit more judicious. So the story we were telling, and if you indulge me for 2 or 3 minutes as I kind of lay the groundwork for the story, starts with our current dean, Bill Traynor. Dean concluded early in his deanship that he wanted this law school to focus on law and technology more than it already had been. And he empowered colleagues like Julie Cohen and David Vladeck and Laura Donahue to build centers and institutes and clinics, which led them to recruit all of the people you're going to hear about today. Today, we're proud if a little immodest, to say that this is the top technology law program in the country. I'll say that again. We love to say that we have the top technology law program in the country. And we say that with due respect and tons of affection to our friends and colleagues at fine institutions like Harvard, Berkeley, and NYU, who outwardly probably quibble whenever I make that boastful claim or whenever Dean Traynor does, but deep down inside, they know it's true. They're fine law schools. They have excellent technology programs. I mean no disrespect. And so perhaps it's my burden over the next hour to convince you that maybe there's something to our boastful claim. So let's just start at the basics with facts and figures. We have 17 tenured or tenure track faculty who specialize in law and technology. I'm not talking about the many others who delve deeply into law and technology as kind of a second area of interest. I like to tell incoming students who are comparing us to other schools that our tech faculty is larger than the entire faculty of some other law schools. Every year we offer more than 70 courses, 7-0. We have 2 fantastic clinics, and we're really privileged today to hear from the 2 faculty leaders of those clinics. We have over 80 adjunct professors who specialize in technology, law, and policy. This includes national household names in this field. We have 2 amazing centers focused on this area, the Center on Privacy and Technology and the Institute for Technology, Law, and Policy. The students, of course, are the lifeblood of our work. They're the reason we come every day. They're the reason we're so animated. They're the reason we're so energetic. They themselves have formed student groups, student organizations focused on technology and intellectual property and computer programming. This includes the Georgetown Law Technology Review, Georgetown's newest publication run by students. But at least some years, in the few years it's been around, it's been the second largest enrolled publication after the Georgetown Law Journal. We created a program called the Technology Law Scholars to welcome in incoming 1Ls and some rising 2Ls and really get them to dedicate and focus their studies on technology law. And this was building, of course, on the grand tradition of our public interest scholars and global law scholars. And here's the astounding thing. Everything I listed above, almost everything I said, didn't exist in 2014 or 2015. That's how rapidly we have grown. That's how quickly we are moving. And it keeps coming. I mean, in this year alone, in the last 12 months, we've introduced 2 brand new degree programs, an LLM and an innovative program called the Master of Law and Technology. This latter one, the MLT, is the first degree with that name in the entire world. And it is focused on students who probably have a technology background, maybe they're computer scientists. And what they want to do is talk about technology, law, and policy in a deep way. They want to get a career in technology, law, and policy. They understand that some knowledge of legal education may help them get there, but they don't necessarily want to sit for the bar exam and become practicing lawyers. So instead of a 3-year JD, they come to us for a 1-year innovative new degree program. And as I've said, we welcomed our first class of spectacular superstars this year. And if anyone in the audience is hiring and would like to talk about someone like I just described, please shoot me an email and I will introduce you to some. In the last 12 months, we've also bought a building. The university bought a building, and I'll say more about that toward the end of the hour. And in it, we're going to house all of this vibrant activity. And just as importantly, a lot of our cross-campus partners from the university will also be housed on the law school campus for the very first time, especially around technology issues. All right, so that's the facts and figures. But I want to highlight something that is so much more important than any dry set of facts and figures, which is at Georgetown, we are animated by understanding that technology, law, and policy is fundamentally about important human values. We care about innovation and technology because they're an engine of economic growth and because they lead to things like jobs and employment and revenue. But that's part of what we're focused on. What we really think about with technology is how it impacts human flourishing, how it can impede our ability to enjoy our lives, how it can enhance our ability to enjoy our lives, how it keeps us safe or how it puts it at jeopardy. We suffuse our work with themes like this. And what I'm going to try and do in this hour, I've got a lot of ambitions about this hour, is I'm going to try and coin a phrase. I think what we have here is an emerging Georgetown School of Technology, Law, and Policy. I don't mean that in a kind of official way. I don't mean a building that gives out degrees. I mean it as a kind of worldview, a school of thought, an approach, an ideology. The Georgetown School says that we study technology because we study human values. We study technology because we want to ensure human flourishing. And I've packed this panel with people who live this work in everything they do. So without further ado, let me introduce, and I'm gonna be sparse and probably insufficient with the biographies because I want to get to the conversation. So our first speaker is Alvaro Bedoya. Alvaro, if you will turn on your camera. Alvaro is the founding director of one of the many things I just rattled off in that long list, our Center on Privacy and Technology. He's also a visiting professor of law. He came to Georgetown in 2014, and in a very short amount of time has gained a reputation as a leading voice bridging the civil rights community and technology, law, and policy. And so my opening question to you, Alvaro, is how well do technological advances protect and advance or impinge on and interfere with civil rights? And what can we do to improve the situation? Alvaro?
Hey, Paul, thank you. And I'm going to answer your question, but I just need to start by saying that everyone watching, this may be implicit because Paul is our moderator here, but you, Paul, deserve so much of the credit for this extraordinary school, the metaphorical school that's being built here. And yeah, you know, I remember when you came on faculty, and I think I said that it feels like we've completed the Triforce, which is a Zelda reference. I no longer get to play video games, but yeah, it's just a joy to work with you and everyone else on this panel and all the folks you mentioned. I'll be really quick to answer your question. I think what we bring here is applying these social justice values that are central to the core of the law school to this field of privacy and surveillance and technology more broadly outside of the center, that historically has been really anodyne, really ahistorical, and really focused on things like, cookies on browsers and things that don't really affect the day-to-day lives of an awful lot of people. And to give a concrete example of how the center has done this, and I should say that I run the center together with Laura Moy, who'll be speaking to you about her clinic. So she's a very busy person. I'll just offer one example, which is our investigation into immigration and customs enforcement surveillance activities. I think when you say surveillance agency, a lot of folks think NSA or FBI, but the reality is that ICE is quietly building out a very expansive surveillance network. And we recently revealed through the Washington Post that it had been tapping into utility records in a quiet and effectively secret way that affected probably 170 million Americans. I will say that for the purposes of this panel, what I'm proudest of is how that result came about, because before this was released to the Washington Post, it had been closely vetted, researched in detail by students in a practicum. And they found new information, some DOJ filings that really added important context and flavor about how different kind of shell companies had been used to make this happen. And that, I think, is what I'm proudest of, is not the work, is obviously the work we're doing, but it is how we get there. In the biggest report we've issued, which has had the biggest impact, if you open up the authors page, I think 75% of the names on that page are either current students or alumni. And I think that's something that other folks who do what we do in this space can't say. And that's what I'm really proud of.
Thank you, Alvaro. I've asked our panelists to stay on camera, and after I've introduced them all with one question, we're going to have a conversation. I'll also say I'm super gratified to see so many of you here. We got your RSVPs ahead of time, and many of you submitted questions. And so I'm going to try and incorporate a lot of those questions into the second half of this. We also have the Q&A capability enabled. So if questions strike you during the panel, please ask them. All the panelists can see the questions you're asking. And if my co-panelists, if the spirit so moves them, they could even answer some of them in the box itself. Okay, so I'm going to call next to our virtual stage, asking Alvaro to keep his camera on, Professor Amanda Lewandowski. Hi, Amanda. Amanda is one of our newest members of our kind of tech enterprise. She is an associate professor of law. She's the founding director of one of those two clinics I mentioned, and this is a brand new clinic that did not pre-exist, Amanda, here at Georgetown. We call it the Intellectual Property and Information Policy Clinic. I don't know if we pronounce that IPIP. Amanda's also a leading light when it comes to a really, really fascinating and interesting and very Georgetown school body of work. The way she puts it in her bio is, how do you use intellectual property laws creatively to tackle tricky social issues that cross-cut privacy and technology? And I hope she'll have some time to talk about some of that fascinating research. I know a lot of the alums in attendance practice in intellectual property law. You probably cut your teeth at a Georgetown class on patent law or copyright law. And it may be at the time that was about all we offered. Amanda represents this wave where intellectual property law is still so central to what our students learn about here, but it's a kind of different spin on intellectual property law that really does connect it to other work. So Amanda, I'd love for you to talk to us about some of Georgetown Law's contributions to intellectual property law and policy, for example, through the work of your clinic.
Sure, I would be delighted. So at the IPIP Clinic, one of the things we really focus on is, as Alvaro mentioned, social justice, right? That's what I care about in my scholarship. And that's what I try to teach my students, because they can learn, 17 USC section 107 from Professor Cohen. But from my perspective, what I want to teach them is how they can use laws like copyright and fair use for social justice ends. So that happens in their casework, in the kinds of clients we represent and the kinds of issues we work on. We work on access to justice. We work on better policy for all Americans to actually make the intellectual property system work for everybody. We also do a lot of counseling work for individual artists who have really urgent questions so that they can actually make and create without worrying about what seem to them boring, but to me are fascinating questions at the intersection of copyright, trademarks, and trade dress. But one of the other things we do is teach them skills about how to give back to their community. And one of the ways we do that is, I've been editing Wikipedia since 2011. And when I joined law school, I was, I think, the first person in the United States to create a Wikipedia article for a law school class. I created the article about revenge porn. It will probably be the most impactful piece I ever write. It's been viewed more than 1 million times. It's been cited by the New York Criminal Court for the definition of revenge porn. And I want to give that opportunity to my students, because the model rules for lawyers say that one of our jobs as attorneys is to teach the public about the rule of law. And there is no more powerful way to do that than contributing to Wikipedia. It has an outsized effect. It's been cited by every circuit court in the United States. And it teaches students not just the skill set of actually coding and editing Wikipedia, but how to write for a lay audience, how to integrate sources that are freely and publicly available to anyone with an internet connection rather than paywalled behind a Lexis or Westlaw link. And it also teaches them how to think critically about organization, right? It's not the same to just repeat everything that's in an actual case. You have to synthesize and address it in a thoughtful way. And we've now edited more than 12 articles. And I think it's something that the students really value. I've had the pleasure of doing some interviews with one of our alums, Laura Ahmed, who really took to the exercise and I think has gotten a lot out of it. And 100% of our students so far have said that they would consider editing Wikipedia again. So my hope is that this is part of Georgetown's goal of creating lifelong learners, right? You don't stop learning just because you graduate. And this is one way they can keep contributing to their communities.
Thank you, Amanda. I'm going to invite next to the stage to turn his camera on a former student and alum, Kendall Spencer. Kendall is an alumnus of our Technology Law Scholar Program, graduating in 2020. Kendall really did do it all in law school. It was kind of uncanny and amazing to turn around at every instance and see him literally testifying in front of Congress, assisting professors testifying in front of Congress, entering and winning competitions, while excelling in the classroom. Kendall really is the kind of true triple threat and does it all. And although Kendall is a pretty exceptional human being, I'm happy to say that he's, representative of what we see at Georgetown. We attract kind of this elite group of former leaders, but as we've been, saying the entire hour, people who understand that Georgetown is a place that cares about values and isn't just about how to, help giant corporations take lots of money from other giant corporations in litigation. And so it's really a privilege to have students like Kendall. So Kendall, I was hoping you could talk just generally about the Georgetown Law training, what you saw in the classroom, what you saw outside the classroom to help prepare students for careers in tech law and policy.
Yeah, so I mean, first and foremost, it's great to be on this esteemed panel, right? Paul, I mean, you've been such a great mentor, and really all of you guys. I mean, I think at one point or another, I've had extended conversations with everyone on this panel, and I'm sure you can remember when we were trying to get the, computer programming, group together, and really, I think what all of that says, and to go back to your question, Paul, is, you come to Georgetown for these type of opportunities, because what happens is, even though you might not see something that you want to be there already, you can have these conversations with different professors and people in the field, and really begin to create the experience you want to see at the school. And I think that is the resounding theme for my experience and so many other students' experiences. It's taking what Professor Bedoya is doing, it's taking what Amanda's doing, it's taking what all these amazing individuals at the school and their activities, taking what they're doing and trying to use that to craft your own trajectory and your own path. And I think that's incredibly powerful. The conversations you're able to be a part of. I mean, if you had told me before I got to Georgetown that at some point I would end up hacking into voting machines, or in front of the, House Homeland Security Committee, showing people how to hack into voting machines, I would have thought you were crazy. But I think coming to this institution with an open mind, I think that really does fit into this broader umbrella of, the Georgetown Technology School of Thought, right? And I think it really is going to be an ideology, because it's an ideology of possibility, of creativity, and really just making sure that you're communicating these ideas to the people around you. The Tech Law Scholars was a great program. I learned, to this day, I still communicate with everybody in that scholars program, the professors that I met, the different groups. I mean, it's been incredibly impactful. And today, the work that I'm doing with intercollegiate athletics and name, image, and likeness, I'm able to take my experiences, not just as an attorney, not just as an athlete, not just as a former Georgetown University student, but sort of weave that into the narrative, and, as Amanda was saying, help use that to explain some of the issues that we're seeing in society today. And by way of doing that, I'm able to help educate the public and create a better future for everybody. So I think that's an incredible experience. And I hope and believe that all of our students have an opportunity to do that, and they feel empowered to do those type of activities. Because again, these are things that when we got here, maybe we didn't see them immediately, but because of the support from the faculty, because of the support from the school broadly, we're able to create these things. And that's something so incredible and worth protecting. And I'm excited to see our institutions continue to do that.
Thank you, Kendall. Yeah, you hinted at a few other things in your bio that we will talk about later in the hour. You're an exceptionally interesting person who does a lot. So I'm going to invite to the stage our final speaker, certainly last but not least, Laura Moy. Hi, Laura. One of the challenges with Laura is she does it all. There are 15 different hats she could probably wear on this panel, and I've asked her to don only a few of them here at the start, but I invite her to talk about all of her experiences. She's an associate professor of law. She directs the other clinic, the Communications and Technology Law Clinic, and I think it's really important at this point to call out the legacy and hard work of people like Angela Campbell, who created this clinic, the IPR clinic, back when no one had technology clinics. And so again, it's this theme of us standing on the shoulders of real giants. She is also, as Alvaro suggested, the associate director on the Center on Privacy and Technology. the one hat I've asked her to wear right now, and again, it doesn't do her work full justice, is she is a central figure on something new really in the last year or two that we are starting to call tech and society. And what this is it's our ability and attempt to go beyond the Law Center and to look at all of the other activity happening on main campus and at the Med Center, and to build some real interdisciplinary bridges. And so I'd love to hear more about how this connects our work that we do here, Laura, what you think, the most important parts of this are for people who haven't been acquainted with it, and how it connects to this kind of broader theme of public interest technology that some have been hearing about nationwide.
Thanks. Yeah, this is great. It's great to be on this panel, and I'm very grateful to you, Paul, for your leadership, and of course to Dean Traynor and to Will for organizing this event. Thank you all. All right, so I'll try to. I'll start with Tech and Society, and Paul, you should feel free to fill in anything that I miss. Right, so Tech and Society, as Paul was saying, tries to strengthen the intersection of the connections between technology and ethics and governance across the entire university, right? So we have so many students who come to Georgetown because they want to change the world, right? We're in DC, and we have this deep tradition from our Jesuit roots of serving humanity and working toward a more just world. And that's what students are coming here to do. They want to serve in governments. They want to do policy work. They want to shape laws in the future. Those are not just law students, right? Certainly our law students, but our undergrads as well, and our graduate students throughout the entire university. And something that has changed in the past few decades, I suppose, is that technology, and really technology that's difficult to understand once you go past the surface level, technology that's growing more complex is now in everything and every major policy issue, right? You want to work on political polarization, you want to work on environmental justice, are you interested in education policy, healthcare, finance, business, any of these areas, you have to have an understanding of technology. And so, and that's particularly the case if you want to do policy work in any of these issue areas. And likewise, policy decisions are being made by technologists who are deciding how to, what the training data set will be for a facial recognition algorithm, right? Who are just deciding what the design will be of the testing for a new piece of software that might be sold to government. And so in order for those students to be able to do that work well, they also have to have an education that is infused with ethics and policy decisions, or ethics and policy considerations. So we have now this kind of overarching umbrella, the Technology and Society at Georgetown Law, that aims to bring together lots of different programs within Georgetown to try to increase interdisciplinary studies and interdisciplinary conversations across the university, and really ensure that justice and ethics are infused in every conversation that we're having about technology, and vice versa. So from the law side, that includes the Institute for Technology, Law and Policy and the Center on Privacy and Technology. And also throughout the rest of the university, we have the Department of Computer Science that's part of Tech and Society, Ethics Lab that's working on infusing digital ethics into existing disciplines. We have the Center for Security and Emerging Technologies that's looking at the security impact of AI and other emerging technologies. The Beck Center for Social Impact and Innovation, Communication, Culture, and Technology program on main campus, and the Massive Data Institute that's trying to actually use data in a secure and responsible way to help answer public policy questions, right? Looking at trends on social media to better understand policy questions. all of these programs, as I said, are meeting regularly and working together to try to do a bunch of things. One, to collaborate on research. So we have a bunch of collaborative research programs right now, aided in no small part by a new fellows program that we have specifically to advance cross-disciplinary research, the Fritz Family Fellows, who are bridging gaps between different programs in technology and society. We're working together to try to develop advocacy campaigns or generally to try to help drive policy and social change by engineering solutions together, cross-disciplinary solutions. We're working, as I said before, to expand our interdisciplinary curricula across both, well, I should say all campuses. It's not just 2 campuses. And then generally just to build and promote the field of technology and society. We do want to do this at Georgetown, but we don't just want to do this at Georgetown. We want to promote these ideas really to the world and ensure that education across the country is infusing technology and ethics decisions, ethics considerations into each other. So that's a little bit about technology and society. I could go on, but I imagine that we'll get there in questions because we've got lots of cool projects.
Thank you, Laura. And listen, I now know that I am an associate dean because I'm about to do something very decanal, which is the Fritz Family Fellowships that Laura talked about are really transformative. It's amazing that there is this money dedicated for us to work with other people. So I wanted to thank Lynn Fritz and his wife, Anicia Fritz. Lynn is an alum of the college, not the law center, and yet in this supercharged way has really advanced the work we do. And everyone on campus now knows Fritz Fellowships are these amazing resources for doing our work. So before I ask a couple of questions, and some great ones have already come in on Q&A, let me just fill in the one piece that none of the panelists have talked at length about because it's kind of my bread and butter, which is our courses. It's really something that we do that is unlike any other institution that I know about. And I happen to be the associate dean in charge of the entire curriculum. One thing I will often tout is how when you're at a law school that's this large, that offers this many classes from this many professors, no subject is too new, too experimental, or too specialized to bring to our students. And it's really a privilege that we have with this curriculum to kind of entertain what might at other schools seem like luxurious topics that are too hyper-specific, but that we understand to be where the future is, where the important questions are being asked, and where our students will really benefit from the kind of deep dives we produce. So I'm going to list a few, but you have to understand there are 20 others I could mention that are along the same vein. We have a really successful class on the law of robots. Alvaro and colleagues have taught an amazing class called The Color of Surveillance, which is tied to a conference series that Alvaro has run for many years. We have a class in policing in the 21st century, biotechnology and patent law. We offer 3 different classes in computer crime law, including one that I teach. I don't think there's another law school in the country that can probably make that claim. But what I really want to talk to you about a little bit more deeply is one thing we've done that truly is new is we have classes that feel more like engineering classes. I've often talked about how I want to disorient people. I want them to step into some of our classrooms and get confused for a moment if they're still inside a law school, or if in some way they've stepped into a wormhole and ended up in the computer science department. 3 quick examples. Alvaro and David Vladeck have co-taught a privacy legislation practicum. Laura has pitched in and co-taught some years. And in this class, Georgetown law students sit with MIT engineering students. They bridge the interdisciplinary divide for an entire semester, including when we were allowed to, before the pandemic, flying back and forth a couple of times to see one another in person. And their goal is to develop model legislation for some of society's toughest issues. And I can personally attest to how amazing the end products of these interdisciplinary collaborations truly are. Secondly, we have this amazing colleague, Tanina Rostein, who created this class called Technology, Innovation, and Access to Justice. And in this class, law students who know nothing about how to build a web app instead end up pairing with legal services organizations and build apps to better serve the needs of the communities served by these groups. And every year, because Tanina is better than any of us at kind of how to package things and really make them fun and splashy, she has what she calls the Iron Tech Competition. And this year it took place just last week. 2 years ago, I remember the winner was a group of students, again, with very little prior technological knowledge, who built an app with the Whitman Walker Health Group in DC. This app helps transgender and gender expansive adults complete the forms they need to legally change their name. It turned out to be a really laborious and Byzantine and bureaucratic process. And in the span of one semester, these students made a tool that was truly useful and in fact lives on the website of this organization and has been used to help numerous people. Professor Rothstein loved the idea so much that last year she decided pre-pandemic to go global. She's helped inspire classes like this around the world, and she wanted to bring people literally from every continent together here at Georgetown to have a competition among the winners of each class to see the overall global champion. And last year it really was this kind of celebration of cultures in foreign countries and people who are coming from very different points of view, but engaged in the same sort of enterprise. It just so happens, here's my ad, that the second annual International Invitational is tomorrow. So please visit the website of the Georgetown Tech Institute or look at the Iron Tech Twitter account to find out how to access that show. And then the last thing I want to emphasize is for 6 years, I have taught one of the nation's first courses in computer programming for lawyers. Every year, 50 to 75 law students with zero programming experience learn how to code in Python. This means that since I've been here, 7 to 10% of Georgetown JD students learn to code while they're in law school. And what I tell them on the very first day is that, to me, coding, this isn't about some kind of far-flung, ambitious way to make you a more nuanced tech policy lawyer, although I think that might happen for some of them. I just think of programming as this essential skill that every lawyer can use in small quantities, regardless of their specialty. When I'm feeling especially ambitious, I like to say that coding in 2021 is what word processing was in 1980, where lawyers considered this odd new technology and other skeptics said, why would we ever give up our dictaphones? And yet here we are. It's hard to imagine being a lawyer without understanding word processing. And so I hope in 40 years, it's equally anachronistic to think, there was a time when lawyers didn't know how to code. How odd. Okay, so let's get to some questions. And again, keep them coming in the Q&A panel that we're looking at over here. And what I really heard from a lot of the questions in advance is, even though we're together for only an hour, and even though we're focused on Georgetown and its contributions, I think you all want to hear these experts talk a little bit specifically about some of the substantive issues. And so the first one, I think I'm going to start with a direction at Alvaro, but then I'm going to invite literally anyone on this panel to chime in, is about the state of privacy and surveillance in 2021. And you've started to kind of talk about this with the work that you and the center have done around ICE. I think I just want you to tackle the bigger global question, right? So from the Consumer Privacy Bill of Rights, which was kind of all we talked about toward the tail end of the Obama administration, to the rise of the GDPR in Europe, the CCPA in California, and I'm sorry for the acronym alphabet soup, to the Trump administration and kind of its approaches to surveillance and other questions, to the first 100 days of the Biden administration. Where do you sit when it comes to privacy and surveillance right now? Are we in crisis? Has it become an afterthought? Are you optimistic? I know it's a big question. Take it in any direction you want, Alvaro.
I'll offer two opening thoughts and then pass it to my colleagues who have just as valuable insights here. The first is that the center of power has shifted, and I think that's obvious to everyone. Back when I was doing oversight in the Senate Judiciary Committee, it was us and a couple other offices who were kind of holding Silicon Valley's feet to the fire. But nowadays, Silicon Valley isn't all that popular in a lot of sectors of society, and I don't think that's a good thing for just beating up on people that are successful. I think it's a good thing for accountability and for having meaningful privacy and other protections for the American people. And for me, I think the most exciting work on privacy is happening at the state level. And I mean that both commercially and vis-a-vis the government. Not just the CCPA, but there have been laws passed and proposed in Virginia and Florida and all sorts of other places that build on a tradition of earlier state privacy laws like we have in Illinois and Texas with respect to biometrics, that are really testing this idea of laboratories for democracy for the states, and are frankly occurring because the United States Congress has stopped legislating on privacy. It used to be, and there's a great piece from the Center for Investigative Reporting that I'll try to find and put in the chat, where they plotted out federal privacy laws, and they came at a pretty regular tick where, there'd be some new innovation, and then a couple of years later, there'd be a law and so forth. And then right around, I think, passage of the HITECH Act in 2009, it just stops. And that is when all the lobbying money from Silicon Valley kicks in. And I don't blame them. That's what I would do if I were them. But I think the states are responding to that gap. And on the government side, what you've seen in response to very expansive surveillance practices by ICE is lots of states cutting off warrantless flows of information to ICE, saying, hey, look, if you want this information, get a warrant. Nothing terribly radical, but I think a common sense mechanism to respond to what have been, warrantless, hundreds of warrantless searches of every Maryland driver's face. I live in Maryland. My face and my wife's face have been scanned, hundreds of times by ICE without a warrant, and states are responding to that. And states are trying to stop it. But Laura, Amanda, Kendall, and Paul. I don't know. Eager to hear what you think about this.
Yeah, Laura, why don't you chime in next?
I'm definitely happy to chime in. Yeah, this is great. So I'll echo everything that Alvaro said, but I'll also let me pull on another idea too, which is that I think historically we have kind of thought of privacy as something that is mostly individualistic, right? I have information about myself, and I should have control of that information. Don't spy on me. This is my private life, right? And in the past, something that has shifted in the past decade, I would say, I don't know, maybe, I guess it's longer than that. And of course, there are people like Priscilla Regan that have been talking about the social implications of privacy for far longer than that. But fairly recently, we have really shifted in our understanding and in our policy conversations to a conception of privacy that is really social and collective in nature. We're starting to recognize that the harms from information collection and use fall on all of us collectively as a society, and can destroy all of us collectively as a society, right? So disproportionate surveillance of historically disadvantaged communities can help perpetuate structural inequities and oppression. And use of our data to target content, which we see all the time now, everywhere that we go online, that we're seeing that that's leading to political polarization and amplification of hate speech and discriminatory advertising, all these things that are very huge societal problems and not things that fit into the classic individualistic framework of privacy. And as Alvaro was just saying a moment ago, similarly, with police use of data, there's this fundamental shift in law enforcement power with pervasive face recognition technology, or with law enforcement access to granular location data about all of us, historical location data that goes back sometimes for months or even years. And that's a fundamental shift in law enforcement power, as Alvaro was saying. So that's something that doesn't just implicate each of us as individuals, but are really these big societal problems that we need to grapple with. And I think one of the challenges in figuring out what we do about privacy is moving from a framework that has traditionally been based on the idea that we need to give individuals control and protect individuals from individual harm, to a framework that really understands that we are looking at societal problems, and we may need to decide as a society what types of data uses we're okay with and what we are not okay with collectively as a society, regardless of what any individual may say about their information, because the collective costs are too great.
So what I want to do is, if Amanda or Kendall want to add on to that. They should be my guest, but Amanda, I'm going to first ask you also to expand to a second set of gigantic issues that I know you've written about, and that's the question of artificial intelligence and bias. And so your Job Talk paper was all about this and kind of overlapped with copyright in fascinating ways. And side note, you gave the most electrifying job talk, which is basically law professor for interview, that I've ever seen. And I just remember how fearless you were, taking on colleagues who had been in the business for decades, and instantly everyone in the room knew, okay, we have to find a way to have this woman join our faculty. And so as I ask this question, I also think a lot about the facial recognition work of the center, which really has been instrumental in kind of bringing to policymakers in particular, but the public at large, these very questions about a very important form of artificial intelligence and bias. So Amanda, is there hope here? Is the bias kind of that's baked into so much of what we're seeing in artificial intelligence kind of a permanent condition? Have the politics kind of gotten ahead of us? Or is there still hope that society can wrap its arms around some of these problems that we've been facing?
Yes and yes. And I'm actually so delighted because I hope I can bridge this question to bring it back to privacy, but
Awesome.
we're going to see if I can actually do it. So one of the big questions that was sort of plaguing the machine learning and AI community and continues to plague it is this question of bias, right? You're getting these biased results. You're getting cameras that don't recognize faces for people who belong to Taiwanese American backgrounds. You're getting Google Photos tagging images of Black people as gorillas. You're getting a variety of problematic results. And at the base is a training data problem. And so there had been a lot of focus in the academic literature and the practical work around, well, how do we debias these algorithms by just adding more images? But there was not really an analysis of why this problem was happening. And I came in with the lens of they're being attracted to garbage data that's free and easy to use because of copyright problems. Now, the machine learning engineers are not sitting around being like, ooh, this is copyright infringement. I'm not going to make dozens of copies so that I can create an algorithm that can recognize pictures of snow leopards. That's like the kind of banal explanation that I like to use is images of cats. I have a cat. I think she's banal in a great way. So that's where I go. She's not offensive. She's not dangerous to privacy or civil liberties or dignity. And so when you're doing these kinds of machine learning exercises, you need hundreds of thousands of images. And every single one of those is potentially an instance of copyright infringement. And so I looked at this and said, can we use this exception to copyright infringement called fair use to create literally fairer algorithms? And in a lot of cases, the answer is yes. But, and maybe this time I'm going to reach it back to the privacy work, which is I've been steeped in this face surveillance question by being here at Georgetown, and it has really concerned me. And one thing that has kind of stood out to me coming from this perspective of someone who works kind of at the intersection of privacy and copyright has been Congress cares a lot about conserving copyrights. And as Alvaro said earlier, a little bit less about protecting privacy. So I started digging around to see whether there was a potential way that we could use copyright to resist face surveillance. And my new paper actually says that yes, there is, because for particular examples of making these copies and reproducing them in response to face matches, it's actually probably not fair use because the images are being used for the exact same purpose, which is generally not transformative under fair use. And it affects the licensing market for these images because every single profile picture is technically licensed to every social media company so they can train their own algorithms. So using those two principles, we're able to capitalize on Congress's priorities, which are not protecting privacy, but conserving copyrights, and coming up with something that to the tune of $150,000 per copy can hold these companies responsible for invasive face surveillance. And that's the kind of approach I try to teach the students. We actually use another approach to this privacy copyright conundrum in the context of non-consensual pornography, which I pioneered an approach to when I was a student. And we teach the Digital Millennium Copyright Act to the students through the lens of how do you get non-consensual pornography removed from the internet without engaging in the criminal legal system, which has its own set of problems. Is there a way to do this quickly, efficiently, without a lawyer in a civil context? And the answer is yes. But unless you're looking for those kinds of creative solutions, you're not going to confront these problems in that way. And so I hope that connected every dot that you asked me to, Paul, and I'll kick it back to you.
No, I'm in awe. That really did. And just to let Kendall know what's coming, I'm going to add one more question to you, but you can continue to build this Russian nesting doll if you'd like. But what I want to comment about what Amanda just said, and there was so much rich information in there, is Amanda, your work is really highlighting severe tensions, right? That in some of your papers, it's about unleashing data and information to address things like bias. But of course, when you unleash data, that data is about people. And so you're stepping right into the kind of privacy questions. And literally in some of your work, right, you're kind of an information flow maximalist for some human value and an information flow restrictor for some other human value. And I think that's true in all of our work. I think daily we face that tension. Laura talked about our collaborations across campus. The provost of our university used to run the Census Bureau. His name is Bob Groves. He's an amazing leader. And he really believes that data will set us free. And so it's been so interesting as a privacy scholar to interact with Bob and to say, well, Bob, sometimes that's not true. Sometimes data is the problem, not the answer. And as a social scientist, I don't think that's part of his DNA. And so at a place like Georgetown, where we built these bridges to one another, we don't duck these tensions. In fact, I'm just calling out everyone in this brief hour together. One of my favorite things about Georgetown is that we are in many ways the Georgetown School, which Kendall has now used, by the way, so it's a thing because it's not just me who said it. The Georgetown School, I think in many ways has as its intellectual center, Julie Cohen and the amazing pair of books she's written. And one thing Julie does in her work is she forces herself to feel the tension in the sort of data flow conundrum I was just talking about. And her books really do say, how can you be pro-privacy and clamp down on copyright at the same time in a kind of intellectually consistent way? And what do you think about data flows to empower? Oh, there's the two books. Wow, on cue. Laura had them within arm's reach of her computer. That's impressive. Okay, so Kendall, as promised, this is going to be a little thematically a step in a different direction. So your challenge is to do what Amanda does and make my questions seem coherent. I want you, because we are near the top of the hour, and we'll probably go a few minutes after, but if people have to drop off, of course, I understand, attendees or panelists. So Kendall, I want you to begin to talk about the question of what we call the DC advantage. And that's how Georgetown is situated in a place that allows us to think about the institutions of the federal government, to think about Congress, to think about the agencies that are just a few blocks away from us, and how that was experienced in your time here as a student. And I do want to highlight a couple of things we've omitted about Kendall's biography. I'll do it by way of puzzle. So of the 5 people who have spoken to you, 6 if we include William, one of us is hoping to compete in the Summer Olympics this summer. One of us is a former national champion in the long jump. I'm not going to say who, but one of us is. And for that reason has thought a lot about kind of sports and law and society and how they all come together, and has interacted with policymakers on this front. So Kendall, take that wherever you want. You've done work on election security, with sports and other things.
Yeah, so I want to take it a couple steps back to something Laura had said, which, talking about how we really don't see Congress legislating on privacy as much anymore, right? And I think something that we've seen in the past 5 years or really 10 is the growth of this conversation about privacy at all levels, right? It's happening both at the societal level and also as individuals. And we're seeing the way that interplays with a variety of different sectors. For me, as an athlete, I'll talk briefly about the name, image, and likeness stuff. But Paul, when you start talking about the DC advantage, it's sort of, for me, when I got to Georgetown, I arrived on campus with the thought that when I left Georgetown, I wanted to know that, hey, there was nothing else I could do in that city. Like, if I didn't get to it, if I didn't see a hearing, if I didn't attend a meeting, it wasn't because I couldn't do it. It was because there was only 24 hours in the day and I still had to, attend my Civ Pro lecture, right? So, the way you're able to get out into the city and you know, honestly, I've spoken to some of my other colleagues, you know, and former Section 2 students with as well, is, you know, you could technically take a sabbatical from being a law student at Georgetown, and not attend any classes and still have not nearly enough time to engage with what's going on in DC as you wish you would, right? There is a huge advantage to being right down the street from the Hill and being able to engage with these different policymakers. And you talk about the DC advantage, it really reminds me of, you know, one of the classes we had as a tech law scholar, which was this law, technology, and policy, and really the class that Professor Vogel had helped co-teach, which for me was my first introduction to really learning about policy, because in a lot of law schools, you don't necessarily get that perspective. So being able to take the law, take the you know, the technological understanding of things, and then weave it into a coherent narrative through policy was really important. And that class was important to me because, you know, one of the activities we did was, you know, we had a role play simulation where, you know, we had senators on one side and policymakers on another side that were outside of the government, and we were going back and forth to propose policy. And one of the individuals that I was going up against was Senator Blumenthal. So fast forward to last year when I testified in front of the Senate, who's right in front of me? Senator Blumenthal. And so for me, that was amazing, right? Because not only did I have all the background information, but you talk about not ducking tension. And, you know, surprisingly enough, I felt pretty comfortable, right? Because I understood what was going on, and I had a lot more information than I think would have otherwise been assumed about me. And one of the issues that I really tried to bring this back to was this issue of privacy, and how all of these problems that we're having in areas like college sports, we're talking about paying student athletes and name, image, and likeness. It's all connected, right? You talk about name, image, and likeness, that's the right of publicity, which comes off also out of this right to privacy. And it's getting people to understand that, but more importantly, getting people to understand and getting the policymakers to understand that a lot of this takes place through technology. As a student athlete, we live on social media platforms. You cannot talk about name, image, and likeness and compensating student athletes without talking about how we regulate social media platforms and the ability to do that properly, effectively, fairly, and efficiently. You can't do it, right? And so one of the angles that I was speaking to the senators about was really understanding, and I'm going to quote Professor Hyman on this. If you've had him, you totally understand. I say this all the time. When it comes to these issues, it's not about getting it done, it's about getting it right. And something that I was telling the individuals in the room was, you know, I understand what we're trying to do here, but we need to understand the framework that this all has to happen under. And if we don't have a firm grasp on privacy, potential privacy legislation, and these emerging technological and social media platforms, we're not going to get it right. And we're going to be right back here in a couple of years having the same problem, and it's going to waste all sorts of money and time. So that's a long-winded way of saying that at any other school, I don't think I'd be able to do that, because I was doing that in between classes, right? So that to me is one of the unique advantages of not just being in DC, but of going to Georgetown Law, because I could have a meeting with Professor Bedoya and 3 hours later be on the Hill and be back in time for computer programming in the law, right? And so it's having an opportunity to engage with all these different playmakers in the industry, and again, using that to inform and create your own path in your trajectory, which is, you know, obviously allowed me to, you know, engage with voting security experts, and, you know, I was with the Institute for Public Representation, our clinic, one of my favorite clinics on campus. And so you can bring it all together, and it really helps the classes that we attend really come to life.
So I knew when we put this together that the time would go quickly, and I would be dying to kind of keep these people for 24 hours and just chat. I as I said before, if anyone needs to drop, please be my guest. So what I want to do then is just ask one more question, ask the same question to the entire group. I think we'll go in the same order we started with. So Alvaro, you get to tackle this question first. And given how much I've enjoyed this conversation, this question is, let's imagine we get the band back together in 3 years or maybe 5 years if you're feeling really ambitious. And we are kind of checking ourselves on the optimism and excitement and energy that I think has been palpable in this conversation. And we're looking back at the 5 years and saying, what is new? What has changed? What is different? How is Georgetown having an even more profound impact on the world? Or what is kind of, the recalibration that we encountered in those 5 years? What's the big bend in the road that you see for tech policy generally, but for this institution specifically? So Alvaro, why don't I start with you?
Sure. What I hope is happening, and what I think is happening, is there is increasingly this realization that there is not this thing called tech and these other sectors of society. That nowadays tech is those other sectors of society, and those sectors are tech. And the bend in the road that I hope we're on is people see that privacy isn't just ones and zeros and cookies on browsers. It's can you go to work at an Amazon warehouse and have a sense of dignity and have a sense of self-control and autonomy in doing your labor? And this is coming up in the Bessemer plant. Can you live your life as an immigrant and feel that you can live without always looking over your shoulder? And so having this sector of our society, the law and policy, recognize that that technology and surveillance isn't this thing about smartphones. It's about worker rights. It's about immigrant rights. It's about civil rights. And I think if folks can look back 5 years from now and say that Georgetown was one of the institutions at the center of that, I would consider that wild success, and that's what I hope we get to.
Appreciate that. Thank you, Amanda. Same question. Next 5 years.
I think we're going to see a shift toward more explicit conversations, less about technology and algorithms and bias and privacy, toward power, because I think that's really what this comes down to in almost every case. On the one side, you have questions of consent, right? And that covers copyright infringement, really a question about consent at its base level. Base surveillance, really a question about consent at its base level in a lot of ways. Consent and power, I think, are going to be the two driving conversation pieces. And I think what we're applying those to is probably going to change a little bit over the next 5 years. But my hope is that we can have more sophisticated conversations about who holds the power, how it's being deployed, how that relates to the consent of the people that it's being used to govern, whether that's by the federal government, an agency, law enforcement, or a private company.
Thank you. Kendall, same question, next 5 years?
Yeah, I think sort of similar to what Professor Bedoya is saying, I would like to think that in the next couple of years, technology is no longer this monster under the bed for a lot of people that people don't want to talk about. I would like us to get to a point where, again, technology becomes just an automatic component of the conversation, and people have this working understanding of these issues to be able to use that as a framework to tackle even bigger issues. I would like us to hopefully get to a point where we understand what privacy is, and we've worked on defining that and really getting to a point where, okay, well, what is privacy? And more importantly, well, what do we want privacy to do for us, right? And I think when we answer those initial questions, we can get to the bigger questions of, okay, how do we make this work? So I think in a couple of years, hopefully we can start working towards that destination.
So me, I cannot resist at the very end saying a few more things, but Laura, you get the last word for the panelists.
Okay, all right. So, and I'll take us to a different place, which is something that I was just reflecting and realizing and can't believe that we didn't mention before now, is that in addition to having the best tech law program, we also have the top clinical education program, right? And Amanda and I both direct clinics at the law school. Alvaro directs a practicum and has directed a clinic in the past. We're really big on experiential learning. And something that I'm really excited about in the next 5 years is an increase not only in our experiential learning and technology issues, but specifically cross-disciplinary experiential learning. So just this semester, I co-teach for the first time a practicum that is for students in the Masters in Law and Technology program, where those students are actually contributing to cases that we're working on in the Communications and Technology Law Clinic. And I'm really excited about the future of how we could integrate technologists into our experiential programs even more in the future. So, we're definitely going to have them continue to have them in the tech clinics, especially when we move into our new building, which Paul, you may or may not get to. And but it would be great to have technologists, as we've talked about. Technologies and everything now. It'd be great to have technologists integrated into our criminal defense clinics and our juvenile justice clinic and our health justice clinic. You could imagine amazing ways that we could continue this trend toward cross-disciplinary work with technology and law in all of these areas in our experiential programs.
Thank you, Laura. Yes, that is exactly where I was going to go next in terms of the new building. So it's typical at the end of a talk to have one slide that says how to reach me, and then there's an email address and a phone number. Well, you know how to reach any of us if you just Google us. But what I wanted to show you instead was, here's how you really reach us going forward. So this is the blueprint of the law campus. You all recognize it. And this big bright blue building is the new building that we bought at 500 First Street. And it's a little kind of governmental and utilitarian looking. I will be the first to admit it. But what's
on the outside, only on the outside.
Right. No, I've got more slides. And so what's wonderful about it is the 6th, 7th, and 8th floors were dedicated to tech and society, to the program that Laura described. And we were invited to come together in some of the most enjoyable meetings I will ever have to imagine the physical space that would support the kind of work we've been talking about. And to give you only one example, here's the blueprint for the 6th floor, which is where Alvaro and Laura's center will sit, this dark blue color in the upper right corner. And what I love most about it is the other spaces, the kind of convening spaces. I mean, the offices will be spectacular, but here's the lab. These benches are going to be covered with the kinds of election machines that Kendall was hacking in front of Congress people. And I remember when we chose the butcher block, and I was so excited by how excited this was going to be. So answer one to, if you need to find me, look inside the lab on the 6th floor. By the way, to all our alums, I think none of these spaces are named for anyone yet. So here's a real opportunity for you. But where you're really going to find me is elsewhere on the 6th floor. You're going to find me here in this lovely cafe space that we've created. I intend to have all of my meals there when I'm in the building. I've already announced that kind of one day a week, I'm going to buy a sleeve of cookies, but because my public health colleague was giving me a hard time, probably a bag of fruit as well. And we're just going to convene and come out of our offices and chat and interact and probably dream up the kind of things that are going to enable the next 5 years that my co-panelists just talked about. So that's where you'll find all of us, right? Laura, Amanda, Alvaro, and I will all be housed in this new space. And we're so excited to get back, not only in person, but to get back to this building. And what I want to leave you with really does echo what everyone said in that last question about the next 5 years, right? Part of the beauty of what we do at Georgetown is we don't think of technology as this kind of force of nature that's outside our power to control. We instead understand that it was created by people, all technology, and it's shaped by people, and it can be changed and fixed by people. And so we enter into all of this work with a kind of real sense that we're not passive observers. We actually have a role to play in changing the world as it operates today. We have mottos. It's kind of funny that we have mottos. Most law schools don't have mottos, but you no doubt, many of you have heard the dean say, law is but the means, justice is the ends. I feel sort of the same way about technology, right? Technology is a means for accomplishing lots of things, but in the end of the day, we're looking for things like equality and justice, and as I've said several times in this hour, human flourishing. Probably the favorite motto I've ever heard was only said once in one meeting, and I won't attribute the speaker because she may, although she probably wouldn't care if I said her name. I was in a meeting once and we were talking about some particularly complex issue about tech and society and equality. And I think it had something to do with artificial intelligence. And one of my colleagues said, why don't we just Jesuit the hell out of this thing? And I think I had been here a month. I didn't really know what that meant. This person isn't, a Jesuit, but I think what the person meant was we're an institution that centers humans and centers values and talk about it fluidly and fluently. And I think that's what we're bringing to the tech game. I think that's the Georgetown School. I'm trying really hard to make that a thing. This suffusing these conversations with values. And I hope you all got a little taste of it in this hour. I thank you so much. I really, really do want to commend to you the 150th website, where you will eventually find a video of this conversation, links to the final conversation involving judges, and all of the amazing conversations that have happened. I want to thank William Bailey and Kyle Bernardos and everyone else in the staff and administration who have made this series so successful. And last but not least, I want you all to please join me in this kind of weird Zoom virtual way that we're subjected to doing now in thanking my co-panelists, Laura, Amanda, Kendall, and Alvaro. Thank you all.
Thank you, Paul.